Disturbing truth number one. The trustee can bring a case even if he has no case. What's disturbing is that many people believe that if a bankruptcy trustee brings a case and starts a lawsuit, he must have a very good reason for doing so. But all the trustee has to prove, and I'm simplifying a little bit here, is an insolvent debtor made a transfer to a creditor during the 90-day reach-back period. That's all he needs to prove, and it's not very hard to do. The trustee can bring this case even though the defendant may have ironclad, slam-dunk defenses, such as ordinary course, new value, contemporaneous exchange. The trustee has no clue, most of the time, what defense the defendant has. He doesn't have the evidence. He doesn't have the paperwork. And yet many defendants assume that they need to cut a check or they will be breaking the law. Second, many people assume that because a trustee filed a lawsuit, there must be a good reason. The trustee is usually committed to doing the right thing, but the trustee simply doesn't know whether the defendant has any defenses, whether they're great defenses, whether they're mediocre defenses, or whether there are any defenses at all. Just because you're being sued by a trustee, that has no relevance to whether you need to cut a check. Zero. Disturbing fact number two, most defendants assume that when faced with a lawsuit, they are going to have to deal with a hugely expensive, catastrophic situation. Everybody knows how much lawyers cost. A preference lawsuit creates a lot of anxiety for a defendant, and usually the thinking goes something like this. I'm being sued by a trustee who must have a good reason to sue my company. There's probably a good chance I'm going to lose, which means I'll have to pay the full amount of the complaint and all my lawyer's fees, and the trustee also asked for attorney's fees. I'm going to have to pay those too. What's very disturbing about this is that the actual cost of an effective defense by a seasoned lawyer experienced in defending preference cases is usually a very small percentage of the complaint. Second, the likelihood of any case going to trial is extremely, extremely small. They just do not go to trial. The reason for that is, first, you're usually not dealing with any real fact disputes. Both parties know through discovery who was paid, when it was paid, the context of the relationship, whether there was collection pressure, and the relevant facts. I'm not saying there are never fact disputes, but what I'm saying is that most of the time the parties agree on the facts. Second, the dismissal or a very reasonable settlement of a preference case is very achievable with a position statement. In other words, the trustee has no interest in spending a lot of money on discovery and trial in a case if he's not going to win. If you have it all in a decent brief with exhibits, you're going to get the case resolved quickly and economically. The third disturbing fact is that many times defendants' counsel hold the same misguided beliefs I just described. When a generalist lawyer overestimates the cost of defending a case, he's usually right. That lawyer is going to have to start from scratch. He's going to have to read dozens of cases. Every single document he drafts will have to be drafted from scratch. The last disturbing fact is that even if the defendant hires an experienced bankruptcy lawyer, that lawyer may be conflicted and recommend a much higher settlement than is necessary, costing the defendant thousands of dollars. The problem is that a lot of bankruptcy firms represent both defendants and plaintiffs. In other words, there may be a situation where the lawyer is representing the defendant is going to do everything possible not to offend the trustee/plaintiff. So what kind of a lawyer do you need? You need a very experienced lawyer that focuses almost exclusively on defending preference cases, and that represents only defendants to avoid any possible conflicts with trustees. You need a lawyer who's not going to bill you for his education and make you pay for beginner-type mistakes.